In this video, we're going to talk about how to become a permanent resident in this country if you are the father or mother or minor child of a U.S. citizen. In a different video, we talked about how to become a resident in this country if you've come to this country and you marry a U.S. citizen. Those three groups of people, parents, father, mother, spouses, or minor children, form a part of a group in immigration law known as immediate family members of a U.S. citizen. Immediate family members of a U.S. citizen, as long as they have come into the country legally when they first came, can be in the country even an extended amount of time without documentation and then eventually become permanent residents in this country. But they have to be part of that specific category, immediate family members of a U.S. citizen, which is parents, spouses, or minor children. If you are a parent of a U.S. citizen, or if there's a minor child of a U.S. citizen, there's a process that you can follow that you can become a resident in this country. You would send an application called an I-130, which is a family petition with documentation proving the family relationship, normally a birth certificate. Also the application for residency, sponsor application, an application for a work authorization, and then the form that the doctor will fill out after a physical examination. Those all get sent into USCIS, and the cost is around $1,800 depending. Immigration has announced that they're going to change those fees, and so my suggestion is to check on the USCIS.gov website or talk to an immigration attorney at the time you decide to file these applications to make sure you know how much the applications cost and what fees to send. They're always changing. Once those applications are sent in, it depends on the backlog in the specific state or USCIS office where you've sent the set of applications. Sometimes it can take 2 to 3 years depending on the scenario, because sometimes it can be a little bit less, sometimes it can be a little bit more. It just kind of depends on the backlog in the specific location. While the immigrant is waiting for that application to be approved, they can be approved for a work authorization. Work authorization comes, and also you can request a social security number so the person can start to work legally in the country while they're waiting for that process to go through. One of the interesting things about this process is that normally they won't do an interview for this process. They normally do an interview for when somebody is married to a U.S. citizen, because they need to interview the couple to see if there's a valid marriage. It's kind of hard to falsify the birth of a child, and so oftentimes they won't even do that interview. They'll see that everything is in order, and then they'll approve the application. I've had other cases in the past in this same category where we have done interviews with immigration officials at the USCIS offices, but it's normally if there's some other issue. Maybe there's some criminal history, maybe the immigration officer is not understanding how the individual came and went for the United States over the years. Sometimes this happens with people who live in northern Mexico who have a border crossing card and they've come back and forth several times, and so the immigration officer wants a meeting just to determine whether the person ever stayed in the United States illegally or came back and forth. And again, if somebody comes in legally in this particular category, they can even stay in the country months and years with no documentation after that time has expired, if they haven't left the country and come back again, right? And they can still become a resident. So it's not necessary that they still be in a valid status once they file this type of application. It's just necessary that their last time coming into the country, they were in a valid status on some type of visa or some other permission to come into the country legally. In the description below the video, we'll have several links to the different applications and more information about this process. And it's important that somebody understand the following concept. If the person came into the country with no documentation, it's a completely different process. Parents of a U.S. citizen might have come here and had a child and thought for years and years and years and years that they're going to be able to have the opportunity to become a resident once their child turns 21 and can petition for them, right? And that's another concept that's very important in this stage, is to understand these petitions can be filed once that son or a daughter that's a U.S. citizen turns 21. Now, if the person came in with no documentation, there's a completely different process. You might have to get a waiver, or if the U.S. citizen son or daughter is in the military, there might be some type of parole in place, is what we call it, that the person can apply for as a type of a waiver for that scenario. But normally, if the father or mother came in illegally to the country, there's going to be a completely different process, and so that wouldn't be a process where they could be approved for residency without some type of interview or extra steps, right? But as long as a person came in legally the last time they came into the country, and they're an immediate family member, parent, or a minor child, or a spouse of a U.S. citizen, even if they've been in the country for a certain amount of time without documentation, they can still become a permanent resident in this country. We'd like to help you with this. We have a lot of experience with it, so you can check out the descriptions and the link below about how to contact us. Send us an email, get in contact with us, and we're here to help. Our promise always is to give our clients the best probability possible at achieving their goals and becoming a permanent resident here in the United States.